Okay. Hello, everybody. Thanks for coming into the work group for the criminal performance standards. We may have a couple other members joining us as we go along, but we're going to get started now. It's a couple of minutes after 1:30. So my plan, unless anybody has a immediate issue, is to go through. I'm going to share my screen. And we will go through the draft that we sent out over email and take it step by step.
Can I recommend that since it's unlikely we'll make it all the way through in an hour and a half, just that anyone should feel free to direct us to an area if they have something they think we want to discuss as a group, as a priority. And then if there's anything we don't get to, please email me and Jordan and or make comments in the document on the Dropbox.
Yes. Kevin?
I just have a quick question before we get started. We had that email that went through that they were talking about adopting some of the standards into the contracts and stuff like that. And because of that, I'm just wondering, at this point, what is the intention for how we're going to use these particular standards, so that that lens to review them through.
Good question. So as I understand that right now, and again, this may be subject to change as the contracting process goes on or as we get more information from DOJ, the standards that are in the contract are the kind of base measurable performance things that we can look at. So very similar to what was in Exhibit C beforehand. I'm sorry, beforehand being the last contract cycle, with a couple more measurable things thrown in, like, visit your client within X amount of time kind of stuff. What we're doing with these is the more, I hate to use the term aspirational standards, but aspirational standards of this is what it is to be good at doing public defense. You've got the baseline and then the good line, I suppose. If that makes sense. Colin, does that seem about what we've got?
Yeah, man, I think to get to the question a little bit more directly, we don't anticipate at the moment that what we are now as a group discussing will be included in the contract. This would be used for performance improvement. Ultimately, the goal would be to try to hold providers to these standards, not via contract, but via oversight, observation, mentoring, like guiding trainings that OPDC in the future hopefully will create by identifying areas in which either an individual or a sector of the provider population is not meeting some of these standards, and then targeting our efforts to improving that either at an individual or group level.
Thanks, I appreciate that.
Okay. So unless anybody's got anything huge in the introductory paragraph, I'm going to skip that. Does anybody have any of the standards they'd like to start with? Okay. And we will go down the list. So
I think one thing, sorry, Jordan, I know I keep jumping in. I think it's important to highlight that a change we made, which I think is not ideal, but maybe the only realistic path, given the time constraints we're under in getting this initial version of standards out. The state bar standards on which these are largely based has kind of black letter standards, and then underneath that it has implementation. Some of which sometimes implementation looks like how to do the black letter, and sometimes it looks like aspirational. We have adopted language that makes the black letter and the what was called implementation more like best practices, so more kind of explicitly aspirational, which I think in some cases is not ideal. I think there are certainly some things that are listed in best practices that a lot of people would say are black letter, but it seemed unwieldy to do anything else, so we were directed to take this approach. So I think if there's anything that anyone feels really strongly about that is mischaracterized, that would be something that could be highlighted. But I think, you know, if a provider, if we find out a provider is not doing something that is clear black letter, that's a place where OPDC could take an intervention and, you know, in response to a complaint, for example, if something's in the best practice category in the future, then we would try to work with them to improve their practice. Does that all seem right, Jordan?
Yep. The other thing I suppose that's worth noting before we dive into this is whatever document comes out of this has a shelf life of about a year. It'll then get reviewed again and changed. And I think the plan currently is to review it after a year, make whatever revisions need making, do that again in 2 years, and then put it on a 5-year review cycle so that we're not dealing with the situation we're dealing with right now, where I think the OPDS best practice standards are from like 2010. So hopefully, you know, what we do here will not be somebody looking at it in 15 years going, what were they thinking? But yeah, so with the preamble done, role of defense counsel. Anybody have very strong feelings about any of the language here? I guess I should check.
Yeah.
Anybody need this bigger or smaller? All right, thanks. Sorry, Kevin, go ahead.
Yeah, I was looking at number 5, the deal with pro se counsel. The idea that at any point you should be ready and willing to, I think it implies that you should be ready to jump in and act as, you know, do a full representation role at any point during the criminal proceedings. I think that asks a lot, particularly when the client has gone in. Frequently, they want to represent themselves because they have a bunch of motion practice they want to do that, you know, frankly, isn't legally valid, or the kind of things that we could put in. So I think having an expectation that we might want to jump into a full representation role at the drop of a dime is problematic. I've been in that situation with a client who I'd been doing a ride along for about 6 months. And midway through trial, he got mad because the judge didn't grant one of his motions. And he just sat down and said, I don't want to represent myself anymore. And the judge just said, Mr. Lake, you ready to roll? And I was like, well, not with the mess he's created, you know? And we had some back and forth about it. And then I met with, you know, talked to the guy, and he got over his temper tantrum and proceeded with his case. But it's a difficult spot for an attorney to be in.
How would you account for that with the balancing act that you do need to be prepared to be fully appointed if the court says you're fully appointed?
I don't know that the court should be doing that, I guess, is my point. I mean, that's the reality of it. This person has been in there. Like, I don't like pro se. I don't like doing ride-alongs anyway. If the court's determined that they are able to represent themselves, then they should be able to represent themselves. And if you have doubts about that, you shouldn't be letting them represent themselves. So it's always bothered me anyway. And I came out of Nevada, where I really did most of my early training as an attorney. And in Nevada, they're much more strict about the things you need to ask and the things the person needs to respond to before you allow them to represent themselves. And they've got a right to do it, but there's a list that they go through that's out of a case. I'm blanking on the name of the case, but it lists everything that you need to know, what you're charged with, what the potential outcome is. You need to before you can represent yourself, you have to not just know what a plea deal is and all that stuff, but you need to know the basic things relating to your charge. And there's just not, I think, clear guidance for the courts here. So they end up getting in this mess, and then they want to try and fix it on the back end. I just don't know that putting an attorney in a position of halfway through a trial that's been royally screwed up by a pro se defendant should be expected to jump in and put their license at risk trying to fix this thing.
Maybe
Frankly,
oh,
sorry.
sorry.
The whole advisory council thing, I think, is us putting our license at risk, because like our name's on it, but they're doing all these things that like are not advisable or are not legal, and we're supposed to be advising them on it. And I think just that practice in general, absent jumping into a trial midstream, is dangerous for our license.
I think it's one of those things that's mostly okay if a judge orders you to do it. I think that maybe this is one of those things that can be smoothed over a lot by adding a like insofar as is practicable, right? Like to the extent that we can, I think that we are really responsible for being as ready as we can, because there is always that possibility that somebody's going to get. I mean, this happened to me in my first felony trial, right? Like my client fired me the day of trial, and was like, and then got to the point where he wanted to testify, and then was like, wait, I really don't want to testify in the narrative. Can you ask him to do a direct examination? And I was like, sure, no problem, right? Like, yeah, of course I can do that. And because I was paying attention, because I was ready, like, because that was my responsibility.
Something like that.
I think
I
there
don't
needs
know
to be
if
something
that's-
in there. I mean, if we're taking it over, I want to be able, and this is how I dealt with it when, a judge tried to force it at one point, is like, if you want me to take this over today, I need a continuance. I need to
Mhm.
figure out what I can do to fix this mess. And I immediately pushed for the continuance. And that made everybody balk and take a minute and, manage to figure it out. But it's, this idea that you're going to jump in after a trial's already started. I mean, hell, I don't want to take over a case like that with competent counsel, much less a pro se litigant.
Mhm.
Yeah, I agree. I think there's a tension here, because I think in an ideal world, everyone would be prepared all the time to jump in if they had infinite time and no other cases to worry about. Sure, you could be ready to jump in. On the other hand, if we put this here, we don't want a judge to say, well, your standards say you're supposed to be ready to go, so why aren't you ready to go?
Yeah.
Yeah.
And I don't know how to resolve that.
Well, and I want to reiterate this. Your client could have done things that, later on we have an obligation to have a compelling closing argument. I had a client who had, he'd spent 7 years in prison. He wanted to tell the jury that during jury selection. He wanted them to know, he wanted to appear in jail clothes. I told him all of these things are madness, that were going to hurt him more than help him. But he wanted me to jump in and start trying the case halfway through after throwing his fit. After all of those egregious mistakes have been made, I can't clean that up and fix that, So, what position does that put me in?
Mhm.
And I guess what what I'm really dancing around is I think the whole pro se thing is bullshit. But if it has to be in
Yeah.
there, we really need to be protecting the attorneys so that the court can't point back at this and try and force the issue if it's an inappropriate position to be doing it.
I think maybe the word that I respond most to is fully prepared, like fully. I mean, I can imagine a world in which we're saying an attorney assigned to actively assist in a pro se criminally accused person should be, prepared and participate. But I don't like the idea, and I think Kevin's responding to this as well, that there's going to be like a switch where you're fully on the hook for every decision that you're making. And I think everyone in this. So maybe it's fully should be prepared to be responsive about the matter to the best of their ability, given the situation, right? And should be prepared to advise the accused and the court if representation should be transferred, and it is maybe like say it is ethically, like you feel ethically competent to do that, or it's you feel like you can ethically be prepared, or if you can feel like you can provide effective assistance at that standpoint, right? I mean, I think a consideration is if the judge says, hey, you're going to do this now, are you going to be providing effective assistance of counsel. And I mean, I could go forward and saying, hey, I'm not going to be effective, judge. I mean, this is too much. What I can, but there's going to be a PCR, which is fine. At some point there's going to be a PCR, but having this built into our standards makes it like, hey, I'm preparing this case alongside my client, and I am putting in, the same amount of hours that I would put in for a regular trial if we're fully prepared, right? So
how about that? Prepared to accept representation in the matter to the extent the circumstances of the case allow, and a requirement that they be apprised of the case.
I mean, I don't feel great about it, but I mean, it's closer to
Better?
Yeah, I mean, if you're going to do it, then I would say when you're getting to the part where the court is doing it, because here's the thing, this comes back to the court making the decision. Hey, I let this guy represent himself. Now I realize I made a mistake. So whoopsie, let's dump it on the attorney. That's bullshit. So if we're going to do something like that, then it needs to say in here that the attorney, if a full representation should be transferred to defense counsel and defense counsel feels that they can ethically proceed, it needs to have in there a thing saying that ethically we have a yes or no in it. And whether the court can ultimately do that or not, I'll fight that every day in court. But there should be something in this language that says the attorney has the ability to say ethically, I can't do it. And then the court can try and force you to do it anyway. But if they want to build that kind of error in, so be it. At least I'm being clear. I don't think I'm in an ethical position to do it. And this should say that.
So the attorney should be prepared to explain to the court why full appointment is not, I'll just say it's not ethical. Within, I'll clean up the language later.
Or the first.
Why not do, and if ethically permissible, will be ready to undertake full representation. And
That's
leave
better.
it at that.
I'm sorry if this is not, if I'm just misremembering, but did we place this at the major felony qualification like attorney 4 in the qualification standards, pro se counsel, or
3, I think.
I don't remember if we put this in there.
I don't remember talking about it.
I just assumed it was, I wasn't part of that process, but I assumed it would just be a case you were normally assigned to and then kind of taken off when the client decided to go pro se. You'd stay on regardless of level. So if you were a CA1 taking off a misdemeanor and the client went pro se, you'd stay right along counsel.
Yeah, that happens a lot. I mean, there's also, if the agency also has the ability to say, these are like ethically tenuous circumstances, and the likelihood that this is going to come back on a PCR is really high. We would prefer it if someone with a higher qualification level or someone who could have a different perspective about a PCR would be assigned to the case. I mean, that's not, I don't want to bring that back, but if we just think about that,
It can take more finesse to do this than maybe somebody in their first year of practice has, for example.
It's just for thought. I don't think we need to revisit those other things, but
That is a good thought, and somewhere we can make a note for when we revisit the qualification standards. I'm not seeing it in there in a quick look. Which is not to say that it's not in there, just the last second or two I haven't found it.
So given what you've written.
So we will.
Sorry.
Oh, go ahead, Kevin.
I
I was
just
gonna say we
gonna
can massage this further if we want to move on, but
I think, given what you did, you have to be ready to accept representation in the matter to the extent the circumstances allow. I'd suggest just deleting that second sentence. Let's not invite the court to do that. If the court thinks they can do it, so be it. We've got our ethical thing in there. We've got an obligation to do it to the extent possible. I think that covers what we need to do without inviting the judges to mess with us.
I'm fine with that. Okay. Any further things on the role of defense counsel? Okay. Education, training, experience. I think we should add, subtract, change in that one. Maybe make the font sizes match.
These look like they came from somewhere specific. These look familiar to me.
They were largely adapted from the state bars standards.
I do like, well, this meeting's being recorded, so I'll save that for later.
Oh, I forgot that. I was saying everything was bullshit a minute ago now. I meant it in the nicest possible way.
All right. Obligations of defense counsel regarding workload, anything in there that we want to mess with?
I don't know, man. Is the agency going to allow us the sufficient time, resources to manage a workload?
Todd Reed and I were having the same
The
thought.
agency committing to doing that?
You're asking the wrong person in the agency, Reed. I don't have the answer to that.
It's a little hard to do that when you
From
get
our,
4 hours a case.
From our perspective of making this the black letter standard and the best practices standard for good criminal defense work, is this comfortable language? Taking the question of,
I think the language is okay. I think it conflicts with the proposed contracts.
well, the commission will have to square that at some point, I guess. But the contracts are beyond the scope of our little work group at the moment. So within the scope of our work group, we're okay with this.
Do we care that it says seeking appointment? Like, is the fact that we've contracted with the agency to receive appointments considered like us actively seeking it? Like, am I going, or is this a consideration? Like, I'm going to the court and saying, Judge, please, I have time and space to do this. Please appoint me. Is that, like, I don't know how I feel about the word seeking, and maybe I'm just being prickly today because of like the other contract news, but
Maybe seeking or accepting.
Well, it does say or accepting in there. I wonder if the seeking that came out of the Oregon State Bar stuff, where they're talking about things more generally, given that these are all appointed cases, accepting might be sufficient by itself.
Sure.
Yeah.
before accepting appointment as counsel.
Yeah, I think just take out that chunk of the sentence.
Mhm.
There you go. Better?
Yeah.
Okay. Initial appearance obligation? Oh, sorry. Back up.
For number one on that, do we want to set expectations for, I mean, I know it's in the contract. I think it used to be in the contract, but it says this includes investigation. Does it mean, you know, is this where we put having a phone, secretary, discovery management system, CMS? Are these expectations that this group want to ensure that all practitioners have as a standard for representation?
I think, well, so I was actually just looking at the contract this morning, and I think all of that is laid out somewhere.
So, you know,
Yeah. So including but not interviews of clients, potential witnesses, legal research, preparation, filings, negotiations, appropriate appropriate support staff services, investigation, appropriate sentencing and disposition advocacy. That's under representative services in the contract. But I mean, if we're talking like best practices, like we have a case manager on staff, and that is amazing in terms of, holistic defense, which I think we should all be striving for, because it can help get our clients out of the system if we can set them up with, say, housing and stuff like that.
This is
So
the floor, right? The standards are the floor. We're setting the floor, I think.
I think we're setting both the first floor and the second floor. The black letter standards would be closer to the floor, and then the best practices would be more aspirational than the flooring would be.
Yeah, see, my problem with that is you
Flooring and
start to
subflooring.
expand this. The other people's idea of how a practice should be run is going to infect what everybody else is doing. And I don't want to get off on a tangent here, but I think one of the biggest problems at some of the bigger public defense firms is they have a tendency to always hire staff, and because they're spending so much money on staff, they can't pay their attorneys anything. So then they have constant turnover in the attorneys, which I think is a bigger negative effect than the lack of a social worker here and there. So you start to put that stuff in here, that becomes the expectation, and you will drive people out of this profession. I don't think it's appropriate. I wouldn't sign off on it. I don't think anybody in our organization is going to sign off on it either.
So I guess,
I'd conversely
Kevin,
off on a standard which allowed someone to operate out of a van and have a per pay answering service without any way for a client to have meaningful access to them.
The contract requires that you have an office. The contract requires that you be able to take messages. Contract requires that you have a secretary. My concern isn't so much about those, it's the expansion of that. And this idea, look, holistic is fine. I can tell you why I disagree with some of the things around holistic representation. I think some of the data is nonsensical, and it's not being compared to apples and oranges. We can go into that whole discussion some other point. But if OPDC starts coming back and saying that we need to have case managers, we need to have social workers, we need to have these additional things, they need to fund it. And if they're not going to do that, we'd end up being in the same position where we can't pay our attorneys anything, and then we have the same turnover problems that they're having at MPD and these other places. So it really is an issue, and I don't want to see it in these standards because it's potentially detrimental. They want that, they can fund it. We can always talk about that. That's a contract issue, but you can be a perfectly competent attorney handling a lot of this stuff yourself. I'm not a social worker. I don't train social workers. I don't want to train social workers, but there are social work organizations that I can communicate with that can do this well, and the state can sure pay for those. But it shouldn't be part of the standards for whether or not I'm a competent attorney, whether I've hired a social worker. I think that's madness, and that's why the system is broken at a lot of places right now. We're just pissing away money on those things.
so I think the overarching question then that we have to answer for this particular project is, do we want to define in best practices what sufficient support services and resources would be? If we define it as sufficient, then nobody, you can get dinged for going below that. You can always do more. More than sufficient is going to be okay. If we define it, then it gives, it gives both sides of that argument a way to push, and something in language that lets that be had. If we leave it as vague, it leaves that out, which
And then
may
we
be
argue
better
on the
for
contract.
all.
I mean, if it's something that somebody's going to be held to, it needs to be defined. Otherwise, it's a moving goalpost. If it's an aspiration, it can be squishier.
And it is currently in our more aspirational section.
I mean, I understand and have a lot of feeling for Kevin's position. And one of the things that I think one of the downstream messages that I feel like we're getting from the agency and the commission is that we are not to set standards that are going to drive people away from the profession, right? We are not to set standards that are going to cause people to look at something and say, I'm not going to do that. I'm not going to take any cases. And the reason I ask this question at this point is that it says this includes investigation, and the inclusion of that investigation invites a list of things that we have defined, we decide in this group, or the eight of us decides are the sufficient support resources, right? And so if we're going to leave it and just say sufficient for the quality representation, which I think meets Kevin's needs, and I agree that we don't want to like drive people away from this on some level. The investigation is somewhere else, right?
Mm-hmm. So you say take out investigation and leave it vague?
I say unless we're going to have a long list, then investigation
Yeah, I gotcha.
should come out of that section.
And there is a whole
Okay.
section on investigation down below, so I don't know that it's necessary here.
Okay. All right. Moving on then.
I mean, I don't think we'll ever move on from this idea, but it's
Well, moving on from this bullet point at this meeting right now. Obligations at initial appearance. No hanging spaces.
you just say like lawyers should appear in the same manner as their clients. I'm just imagining me going to court like one of my clients, but it's just a slightly different image.
In person versus video appearance
I understand that.
is what we're getting at there. Don't wear your pajamas to court, Reed.
I don't know about number 2, and maybe this is just different in different places. Just curious what people's thoughts are. If I have a private retained client, obviously I'm going to talk to them before we go to arraignments and stuff like that. But that's because I know who they are. I know that their date is, and I can take care of all that stuff. And I'm wondering if this line didn't come out of the regular bar thing, because when you're walking in for arraignment on these cases, people got picked up and they're in 48 hours later. I don't know that there really is any opportunity to meet with. And I know it says endeavor, so it's not that hard. But I don't know if that came up or somewhere else, and if people think that that is appropriate given the nature of the practice here.
I think that we should keep it. We're doing them here. We're meeting with. We've had to make it work, but we've got a deal worked out with MCSO now, where we're able to meet with about 85% of people before first appearances now.
Okay.
And like,
how much time do you get? Like, what does that mean? It's like, do you get a list a couple days beforehand so you can set up an appointment and like spend 40 minutes or so, or is it just like this is the list, a group of people?
It's like we average like 7 minutes a pop. We get to go up into the pods. It's like, I mean, it's 7 minutes in person, in private. It's enough to get the information that you need to do an arraignment. And it's a hell of a lot better than like trying to whisper next to somebody in a courtroom. I think endeavor is the right word, right? Like it's the goal. And like, obviously for those of us who are, not getting even appointed until at somebody's first appearance, that's not going to be possible. But, that's a system thing that we should probably be trying to push on.
Sounds fair. I did that when I was in Nevada. I would actually go to the jail and do the arraignments there, and you get there an hour early and talk to everybody, and then sit in the jail, and I'd appear by video with clients. So, I mean, I think endeavoring for that is probably fair because it can make a difference. So,
okay. So we will leave that one as is. Colin, correct me if I'm wrong, but I think most of this is bar standard language for what to preserve. And
I thought somewhere in here we should add, and maybe I missed it, but something about the right to testify at grand jury. Little invoked, usually a terrible idea. But I think it should be in the list.
How's that? Okay. Client communication?
We used to do 72 hours per contract, for the in-custodies. I
Really?
think that's what the last contract said, and it's, like our contract always said 48 with our attorneys, but the last contract from OPDC was 72 hours. Since it doesn't say business hours and you can throw a weekend in here, I think that might be a little problematic. Just in case comes in on Friday and you can't see them till Monday, you're already, not complying.
Yeah.
So either make it 2 business days or stretch it out to 72.
Yeah. I mean, I think we can say, I don't know, 48 business hours or 2 business days. I have real strong feelings about wording there.
I think 2 business days makes more sense because 48 business hours could, in theory, be read as 8 to 5.
Yeah, that's 6 days, man.
I know that I don't like I've been around a couple of different consortia, and some of them are, I think some of them I've seen be a little quicker to make that internal assignment as opposed to like maybe taking a day or so. Kevin, I don't know how quickly your consortium, like do you get that secondary appointment? Like, is it like your consortium gets appointed and then you like assign it internally, or is it like you have a guy show up that day and that person's getting all the appointments? Because it says appointment, and I'm not sure if, like, where we want to start at 48 hours. Like, is it 48 hours from the first appearance or 48 hours from when that lawyer gets the thing,
I think that's a good question. Maybe saying case assignment instead of appointment would make it more clear, because that's the day it's being assigned to the individual attorney or attorney case assignment. Because what happens here is, they do the arraignment, it comes into our office, it gets appointed the next business day. And that's when we start counting our 48 hours.
I think if we do that, we're going to want to put restrictions on how long it takes to assign cases.
Yeah.
So the idea is that you want to get in to see the guy as quick as possible.
Yeah. I mean, at that point, we're talking about people who conceivably within this will routinely have been in custody 4 or 5 days before they have a meaningful conversation with their attorney. And that's not a rule that I would aspire to. Like, that's not a norm that I would aspire to.
Jordan, maybe we should talk about thinking about how in the contract it talks about the responsibilities of contract administrators in terms of assignment, and because it's not really a performance standard, how that piece of it operates. I think the performance standard is once the lawyer gets it, how long do they take?
Yeah.
So I think probably if we all agree that 2 business days is how long the lawyer should have, then as an agency, we just need to put guardrails on how the assignment process happens with the contract administrator.
That makes sense.
But if you're really looking at 2 business days and it takes a day to get it appointed, that really only leaves 24 hours for our attorneys to get up there. That's going to be pretty, we run a pretty tight ship here. I think that's going to be really hard for a lot of places to try and hit that kind of a timeline.
Yeah.
So maybe
we can
2
change
business
language
days
after assignment.
After assignment to the attorney, but then within the contract, make sure you put limits on the time for the case or the administrator to make the appointments.
Mm-hmm.
Does that make sense?
Yep. Just to.
And it's funny because you have more time for the out of custody people, and usually that's easier.
All right. Oh, sorry. Anything else about the black letter of client contact that we need to? Anything in the best practices section of that? Anything else we need to get from clients or give to clients at first meetings? Or generally? Okay, moving on to client release.
We have a stay in touch with a client once per month.
Mhm.
How do we all feel about that? Like, I think it is it could be a minimum. At the same time, there are people that stop being in contact with us also, which is not necessarily on the lawyer. Do we have feelings? Or we can leave it. I mean, I don't have strong feelings about it.
Yeah, I hesitate to put that in just because, our clients can be so transient. Phone numbers changing all the time, emails changing all the time. I think it makes it's difficult to put a burden on the attorney to maintain that client contact when the client's, not to be found.
I feel like that militates in favor of maintaining frequent contact with clients, but that's my practice.
Maybe just say, yeah, I mean, I love the idea of people being in touch regularly, but so many of our clients just disappear, from day to day.
I mean, there's a bar ethical standard, which is we should keep them appraised, and that's, I mean, to me, that arguably that should suffice. I mean, if you want to set a counting date, that's something, right? Like, and if one of my attorneys has 150 clients and they meet with like 5 of them a day, right?
Mhm.
That is what? How many can they meet in a month, right? 5 times 20, they can meet 100 of them in a month. So if they met with 5 clients every day, and they're just going to be meeting with clients all day, right? I mean, if that's what our caseload expectations are, I mean, at some point there's going to be
Mhm.
some conflict. Sam.
All right, hold on, one thing at a time.
I mean, I will say, I think if we think
There we go.
people should talk to their clients that often, then we should put it in the best practices. And if people have too many cases, so they can't meet the standard, that's a good argument for advocating regarding caseloads.
Mhm.
I guess I'm saying I think we should, to your point, Reed, we should set what we think the practice should be and not water it down based on reality, especially for the best practices, understanding that we're not going to, as an agency, tell a lawyer that they are failing to meet performance standards, aspirational best practice performance standards because they can't do what they're being asked to do due to their caseload.
Reading the way this is too, I mean, we've got 2 things for clients who are out of custody, effort to maintain monthly contact or as communication allows. I like that language. Thanks for that. But I mean, my God, you have somebody in custody and once a month is the standard. That's not a lot for in custody clients. I mean, I don't do that. I'm a lot more frequent than that if they're in custody. So yeah, just something to ponder, I guess.
So I think if we think once a month is a good baseline aspiration, we can make it more. We can make it less, but if we think once a month is a good average kind of expectation, then we leave this in, and the realities of caseloads will be what they will be.
Well, I think it does depend on the case status. Like in custody cases, they move more quickly. There's more stuff happening at once. There's going to be more to update the client on. Plus, they're sitting in jail. You're going to want to see them more frequently than somebody who is out of custody. Maybe we're waiting for an appointment for some sort of mitigation evaluation, and that's set 3 months out because everybody's busy. Different case situations dictate different frequencies of communication. I think that with a lot of out of custody cases, every week is overkill, but with an in custody client, that's appropriate.
I guess I don't see the need for both of those sentences since they both say aspire to make it once a month. And it doesn't seem like there's a distinction between in and out of custody or the floor. I mean,
Nah. Yeah.
it might
I
just
see that.
be add the as client's communication allows to the end of the first sentence and then call it good.
Or just use the second clause of that last sentence as the whole paragraph.
Lawyers should endeavor to maintain contact with their clients at least monthly or as client's communication allows.
Yeah.
Okay. Do that. Okay.
Is there a reason
I-
that we can't have, is there a reason that video visits are not acceptable for confidential case communications? Like, is there a reason why it says video visits are acceptable for non-sensitive, non-confidential case updates? I mean,
suspect it's because not all video visits are private.
say that again?
I suspect it's because not all video visits are private. Like we're thinking recorded video. I don't know that all jails have private attorney video visiting. And certainly would be concerned about video visiting with folks who are out of custody, not being private. Like that was the concern we were trying to address.
Oh, the agency has a concern about that? I mean, we got clients in like Florence, we got clients in Oak Ridge, we got clients down, Beach, right? I mean, for them coming into us going out, an hour and a half, or them coming in an hour and a half is sometimes problematic. Like, why not have a video visit? Do you think, is it because the platforms are not confidential? If that's the case, then we can, like, I'm willing to think about that. But
yeah, I think that is the concern, and I also think that this is a bar thing as much as an agency thing. The bar has been delving into confidentiality of various communication types.
Maybe we put in that video visits are acceptable, but then add another thing that says, for things that are sensitive or confidential, attorneys should verify that the video visit is in a private setting, and not recorded. And then that just puts the onus on the attorney to make sure, hey, if you're going to do that, you've got to make sure it's clear. Shouldn't it be
Something like that.
ensure? Ensure, E-N-S-U-R-E?
Probably. don't remember if I gave my I don't like typing on shared screens for reasons of spelling and grammar spiel earlier, but now we have it.
I've heard that spiel.
How's that though? Does that address the concern?
What do you think, Reed? Does that work better for you?
Yeah, I think so. I just, if the bar has different, as an evolving standard on video conferencing, then I need to learn about it. So, yeah, it's interesting for this coming out of COVID. Now that we have all these platforms, I mean,
Well, and I mean, it's like Osh is doing all of their evaluations over Teams at this point.
Yeah. Reed, I think the bar's put out some CLEs on it. I'll try to track them down for you.
thanks.
And anyone else who's interested. Okay. You want to move on to release? Any comments on the black letter of release, client?
I mean, you, Jordan, come from a county in which the court made specific comments about your ability to ask for release at arraignment and specifically said, don't do it. We have delegated this
Yes.
authority to a different agency. So, I mean, I guess having a duty would, like, I'm willing to have that, like, take that verbal beating every day. And I'm willing to, like, encourage my clients, or excuse me, my colleagues to take that verbal abuse from judges because of a different local practice. But
Mm-hmm.
want to say duty? I mean, is duty, is that coming from somewhere? Is that language that, like the bar or ABA suggests as a requirement? Duty is a big word, I guess.
Colin, do you know the answer to that? Okay.
I don't think it's too much of a stretch, Reed, to say that we do have a duty to try to get our clients out of custody, right? Like that's what it's not saying that like at arraignment we have to fight with the judge to, you know, to try to get our clients out if that's not gonna work. But like I the way that I read this is like if your client says like I want to have a release hearing and you think, oh, man, I don't love your chances, dude, and your client insists, then you have the release hearing.
Mm-hmm.
Right? That's your duty. And I think that we have an ethical duty to do that, separate from I think that's the professional standard, right? I think that is the norm for us.
Yeah, I think also the second part of that first sentence qualifies the first part. So it's you have a duty to find it under favorable and acceptable conditions. If that means bail setting or the best you can do, that's what it is. So I think that acceptable to the client may be a bridge too far, but you can ask.
Well, I've had clients ask me to not do a release hearing because it's winter and it's cold outside and they don't have anywhere to go.
Mm-hmm.
Oh, I remember why I had it stuck in my head for this is arraignment, duty to ask at arraignment, because in 2.19 it says lawyers should seek release at initial appearance in accordance with 2.3.
Okay.
Mm-hmm.
Yeah.
I'm sorry.
And it does say as soon as possible
Yeah.
in B, I think, right?
Yeah.
It does.
That's
Yep.
why I was hyper focused on this being at arraignment. So if we are comfortable saying that the duty is not immediate at arraignment, that's fine. Like I said, I'm willing
So I
to
think,
argue
Reed, with the way we're having this written and the way we're trying to structure it, your best practice is to ask the judge for release at arraignments. Your bottom line duty is to ask the judge for release at the earliest possible time if your client wants you to ask the judge for release. And if the earliest possible time in Lane County is a week from arraignment, because that's when they deign to hold their release docket, then that's what it is.
Do we have different feelings for murder? Kevin, do you have any thought about that? Where the murder release hearing is like something different. I'm like, I've seen skilled and competent and well-meaning attorneys and dedicated attorneys not ask for release in certain
Sure.
cases.
I mean, I think it's,
Yeah.
I think that's a strategic choice. And I mean, I think that it's like, I would analogize to preventive detention. I would analogize to, I mean, even in misdemeanors, sometimes it makes more sense to not ask for a release hearing that you're not going to win because that's the strategic consideration. And, but I think that maybe what we need to add here is maybe we need to add a piece here that says like any decision not to do that is a strategic choice that needs to be made in consultation with the client. Because it's not one of the magic rights, but I take it as one of the magic rights that like the right to remain in custody belongs to the client. Right. The right to not attempt to get out belongs to my client. Right. The 60-day statutory right for a murder bail hearing, for a preventive detention, or the 5-day right for a preventive detention hearing, the 60-day right for a speedy trial, like those do all belong to my client fundamentally, in my view.
Yeah, but I think that's fair. That's the way we treat it too.
Yeah.
So I think that's good analysis.
All right. Then I'm
Okay.
happy with the language as it is currently situated.
Okay, and I tacked that note on there about rights, add the client's decision. Anything else about the release language and the best practices that we want to talk about?
I'm just going off on a mental tangent because we've got a judge who never releases anybody. And I've been telling all our new attorneys that it borders on professional malpractice to have a release hearing in front of that judge. Can we just put his name in here to warn everybody?
We were working on the habeas standards, and one of the things we added into the habeas standards was to seek disqualification of judges if they if the attorney believed whatever the affidavit language is. We could add a similar standard into the criminal ones.
2.1 2.1 number 8 says if the adjudicatory judge is assigned at initial appearance, the lawyer should be familiar with the local practice for filing motions to disqualify a judge, discuss with the client, be prepared to make a timely motion.
Oh, good, it's in there.
Another one that says like we should be familiar with the judges.
Yeah.
In our local jurisdiction.
Yeah.
Oh,
That's really key.
That's 1.27 should be informed of practices of a specific judge before they appear with the client. So there are things in here that invite that.
All right. Investigation.
How do you folks interpret the lawyer should engage in a full investigation language? What was the intent of that?
I think it's that lawyers should engage in a full investigation. You should do the investigation the case needs.
Okay.
And it's not to say like in your trespass 2 case, go out and interview everybody the client's ever met, but maybe a full investigation in that case is go look at the scene, see if there are actually no trespassing signs, and
yeah, maybe I'm just balking at the word full because that just seems like, okay, you hire an investigator, you have to do, run everything to the nines. In some cases, a lot of cases require that, some don't. Maybe, if it was a thorough investigation or an appropriate investigation or, something along those lines, just full seems
I
think that's a big,
I think that's why that
squishy
sentence
word.
starts with where appropriate.
Yeah.
Is to address that concern. Do you
I'm satisfied with where appropriate.
Okay.
That
Yeah.
if we're saying that leaves it to the either the professional judgment of the attorney or with the informed consent of the client. I mean, if that means informed consent of the
Mhm.
that's fine for me, right?
Yeah.
That's fair.
Yep. Okay. Anybody else on this one? And the best practices for investigation?
Seven.
That one?
Oh, I'm sorry. I read that wrong. No, I'm sorry. I thought the lawyer and lawyer at the beginning and lawyer at the end was circular, but I see now instruct their investigators only to do so. So I misread that. That's my fault.
No worries.
Paragraph 2 of it references 2.2, which is all that stuff already up in 2.2. And if the stuff in paragraph 2 is already up in 2.2, then maybe simply saying you should, appropriately follow up on information gleaned from the initial interview as 2.2 instead of having all that stuff put in there again.
Yeah, I think that stuff is up there.
I will tag that as a note to go back and compare. But good note.
Do we really attempt to interview all the law enforcement officers? I feel like we talked about that, but I mean,
Yeah.
law enforcement isn't
Mhm.
going to talk to me.
I-
I've got an investigator who knows a bunch of them. He'll sometimes get it done, but they're not going to talk to us. Should that be something that we're required to do? Might be another inappropriate cases we could attempt, but
Mhm.
that seems like a lot to ask.
Yeah, I think
I
maybe
guess it
where
seems like a lot to
appropriate.
ask in something that's a futile effort 99.9% of the time.
Well, and sometimes it's just not gonna. Sometimes it's gonna be counterproductive to pick up the phone and call a cop in a case.
Well, the other thing about that one in specific, like I'm okay with like saying attempt because if Kevin knows it's going to
Mhm.
fail, and then maybe doesn't have to. It's not like a reasonable thing to expect of him, which is reasonable, right? Like the cops here sometimes say like, no, you got to call the DA. Need the DA permission first. But I would, I'm curious about if we should say a lawyer should attempt to interview or a lawyer should attempt to have interviewed, right? Or to have the investigator interview. Like I'm not real thrilled with the lawyer interviewing the police officers as part of investigation to set that as a standard because that would potentially make you a witness, right?
Right. Good call.
And so however you want to rephrase that, I'm comfortable with just being an attempt or make a reasonable effort, right?
Yeah, attempt where reasonable or when reasonable.
I'll figure out which one of those we want to use.
We could ask ChatGPT to do performance standards for us.
I don't want AI taking my job quite yet. Thanks, though.
Hi, agency.
Okay.
And I mean, in terms of lawyer should inspect the scene, that's another thing that I feel like an investigator should do as opposed to the lawyers, or like have the scene investigated, something like that.
Sometimes good to see yourself too.
Yeah.
Yeah.
Yes, but bring
sometimes.
somebody with you.
Yeah.
Who
But
can
also the
testify.
sometimes it should be discretionary, I think, not is. I mean, I like to do that, but I don't do it all the time.
I want to figure out how to add the investigator language. Some of this is going to be, I'm going to workshop that later. Wordsmith, workshop, workshop. All right.
I have to step out for about 2 minutes. I had a call that was scheduled that I foolishly put on top of this. I'm going to go make that call and reschedule it real quick. I'll be back in a moment.
Thanks, Kevin. All right. Anybody else on the rest of investigation or moving on to discovery? On to discovery then. Anybody comments on discovery? Duty to
Looks good to me.
okay. Anything in the best practices for that one? The theme and theory stuff, I think is pretty.
I like it.
Anybody have anything on that? And then the pretrial motions. What are the best practices for that? Oh, here's a question for everybody. Is Cartwright motion enough of a term of art that we don't need to include the like citation for Cartwright?
I think it's fine.
I think so.
Okay.
And I bet if you Google it, you'll find it.
See if we can bring in ChatGPT for Reed. Okay. And into filing and arguing the pretrial motions. I don't know if there are any big points in this to cover, but if
Mhm.
and then the fitness practice.
Yeah.
Is anybody any points in the fitness stuff that we need to cover?
So, as to number 2, yes, the gold standard is a new, fresh, clean psychological examination. The new statute allows for old ones to come in. So if you've got somebody who just is in and out because they're mentally ill and so they get
Mhm.
arrested and then it gets dismissed because they're never able and then they get arrested, you can now submit those as well. So I don't know if or how we want to incorporate that into number 2.
Yeah, I think that's appropriate.
Lawyers should seek prior
And also the lawyer should consider filing a pretrial motion requesting a competency determination only if a private evaluation cannot be obtained. You have to file a motion to have your client declared incompetent or declared unfit. So like regardless, a
Mhm.
motion has to be filed. The question is whether you're filing under 365 or 370.
Yeah, I suspect this is supposed to be getting at, don't ask the court to do the psych eval.
Yeah.
But they
Unless you
can
have
per
to.
statute. Like
They
if
can.
if your client's licking the walls, you can just bring them into court and be like, see, like that's in the statute.
Yeah. Yeah. Don't lick
Um,
the walls in the jail.
should we also? I think the best practice is also for attorneys when if they hit that point to be seeking collateral records.
Mhm.
If they're to the point where they're looking for prior psychological evaluations. I don't know what other people think about that. There may be some variance in that. What do you guys think?
I think that you're gonna have some doctors who are asking for collateral records,
Yeah.
especially if you have a client who's nonverbal or non-cooperative. The doctors gonna need to have something to go off of, otherwise they're gonna issue a no opinion letter.
I
Yeah,
mean,
that's my worry always.
I
Mhm.
routinely have my investigator get releases and go out and, you know, drum up those documents. So,
Yeah. I mean, we could make this its own bullet. More specificity
Also-
about what records you need.
Yeah. And I'm jumping ahead a little bit, but under 3A, well, I guess just in terms of whether to request a competency determination, like your client has a right to be fit. If you're at all concerned, like they need to be evaluated. So the whole like obligations to maintain a normal attorney-client relationship to the extent possible, even with a client in diminished capacity, that's not in, I read that not in relation to, do we figure out if they're competent? I read that in relation to, even when they're at the state hospital, I'm still contacting them, you know, with some frequency and talking about stuff to the extent that they're able to, right? That's not a, I need to maintain a normal relationship with my client, therefore I'm not going to request an evaluation, even though I don't think they're fit. I think it's couched incorrectly.
Okay.
You still
How
have
would
to communicate with your client. You still have to answer their questions. You still have, like, to the
Yeah.
best
Right.
of your ability, you have to counsel them on their options and consequences. They don't like get to tell you, I don't want to be
They don't
found
get to say,
unable.
they don't get to say, I don't want to go to
Right.
the hospital.
I mean, they do get to tell you that. They do get to say, like, I would rather go to community restoration or I would rather go to the hospital. Like, you can advocate for those preferences.
Right.
But
But they don't get to say, I'm not crazy, and they're clearly not tracking anything that's going on.
Right.
they don't get to say, I am definitely mentally ill, and also I would like for you to not talk to the court about that.
Yeah. Yeah. So we'll rework that section. If you guys have suggested language, send it over. Let's see, anything else on the fitness section?
Can we have a timing expectation in the black letter? Like, if you have this belief, you need to do it as soon as possible,
As soon as possible, yeah.
as soon as
Okay.
practical. Like if you're like, oh, this guy's not well, maybe I'll just like wait it out. I'm not thrilled with that kind of idea, right?
Mhm.
Like
yeah, Reed, that's a good point because I mean, competency is ongoing. I've been in mid-trial and had to stop trial. And I think people putting that in the black letter so people know that this is an ongoing evaluation, I think is probably important to have in there.
And I think that's kind of covered in number 7, although a bit clunkily. Where should continue as a matter. Yeah. Yeah. Recognizing that it is fluid.
How's that? Adding those two sentences.
So that's
Cool.
one. One of them is also on number 4.
Mm-hmm.
Number 4 talks about should secure the services of a qualified expert.
Yes.
Do we want to, one, set an expectation that they are familiar with the experts and what they're like, how qualified they are, and what those experts' reputation for good work, timely work, and testimony, like, is that an expectation set for the attorneys? So that's a question 1. And then 2, like, I'm always on, and this is, also comes from some of my coworkers, like, this needs to happen, quickly, especially if your client's in custody. Does that make sense? Those questions make sense?
Yeah.
Well,
I
and in
think we had-
general, your expert is going to be the person that evaluated your client. You're not going to grab some other random expert, assuming that an evaluation happened.
Yeah, but you have to choose someone qualified, not just qualified, qualified and competent, right? Or
Yeah.
Mhm.
do we want to know, like, set an expectation that you should all know whom to use, right?
Mhm.
So I think that makes more sense as a general requirement on lawyers retaining experts.
Okay, great.
I'm going to tag that note. Cool. But I think that is a good thing to work into these somewhere.
The last thing for competency is, do we want to set an expectation that attorneys sit with their clients at the competency evaluation
Yes.
so that, in order to protect their rights? I mean, is that something that we want to set as a best practice, if possible?
Okay.
If possible.
Because there's also, like, the state hospital evaluations that are far away for many people across the state.
But they're doing them all by teams now.
Right. But we don't have a good timing, like, we don't always have control of their schedule, right? And they may,
Mm-hmm.
and then sometimes our clients don't want us there, and then sometimes so that's just, those are some considerations, and I do think it's best. I do think it's a best practice if people be there with the client for the evaluation. I know it's hard for a lot of people, just given the amount of volume that we have and the type of work that we have, and the fact that we are rarely in control of our own schedule.
Mm-hmm.
EAVOR.
Yeah, I'll fix it in post. An evaluation done. Do we want to require them at any evaluation of the client, or just evaluations done not by their own expert?
I think done not by your own expert, because your own expert isn't going to release anything without your permission. And a lot of them will comply when you're like, hey, let's take out this sentence where my guy said he did it.
How's that? Lawyers should endeavor to be present with the client at any evaluation of the client done by anyone other than the lawyer's retained expert.
Yes.
Just to be specific, lawyers may be present by virtual or telephonic means. So we're not confusing, you have to drive to Salem. All right, anything else on the competency piece?
Sure, I'll think of something.
Well, that segues nicely into what I was going to say next, which is it is almost 3 o'clock. This meeting was scheduled to 3 o'clock. I don't want to hold anybody beyond their scheduling. So we can do one of two things. If we all want to hang out and keep going through the next, 20 pages of this, we can do that. Or if people want to email comments in this vein by, say, Monday afternoon, Colin and I can work them in and we can go that route as well.
I have court at 3:30, so I'm gonna have to bounce, but if you
Okay.
y'all want to keep going, don't make me stop you.
I have kid obligations. I've got maybe another 10 minutes tops. Is there anything that anybody is saying, hey, this is a real red flag that maybe we should address as a group, and then we can address that?
Nothing I have.
I have not heard anything.
I have 9.4 post-sentencing disposition procedures.
Yeah.
Like, we have to do all this stuff. I mean, that's not something OPDC is compensating us for, right? That's not something, like, if you are saying that we have an ethical, like a performance standard that includes continuing obligations to our clients after final judgment, then if, like, that is going to take time away from our workload. And so if I am filing motions to modify probation, if I'm filing motions to allow like medical marijuana use on a DUI, if I'm filing what is that is like sort of independent from a correction of the judgment, then I haven't gotten to sub F on the contracts yet, but there has to be a way. Either we're not going to do it, or OPDC is going to have to account for that in our workload, since we have to be 90% of our workload, or else everything's going to go to heck.
I think the answer that I can give you for that, Reed, is that there are certain post-judgment requirements already were in the prior contract. I don't know that this expands on those. I don't think it does, and it wasn't meant to.
Those are pretty expensive, and we can have a different different conversation about that too. But
yeah,
they're not, because we are in a case
there is
not a workload model, and
yes.
This is something that we do or required to do that is not reflected in the caseload.
I think
Penalized
for that, I would direct you to the contract feedback mechanism. I think it's a form, but I think that's going to be the better place than this to argue about what's compensated and what's not. So we can go back to the what should our black letter and our best practices expectations be for attorneys post judgment. But I don't think we can get into issues of compensation for it, if that makes sense.
So the response would be, like if I'm, if we're like Bob used to respond to all of these things and he used to take hours out of his day. If those days prevent us from, if that time prevents us from, if this obligation prevents us from taking new cases, that is something that is going to be like, that's a check that we're going to have to make, right? Like, say, Judge, I can't take this appointment.
Noted.
Got this pile of like post adjudication stuff that I'm still working on.
Noted. I guess the question I would have is, do you think the post adjudication stuff should not be an expectation of attorneys?
I mean, that's the question of the nature of the appointment, right? Like, is our appointment What is
Yes.
our what is the
Like,
What is- what
the
is your answer to
contracts-
that question, Reed?
The contracts define an appointment and when an appointment ends, and it's essentially on the entry of judgment or 180 days after a
Mhm.
warrant gets issued, which then gets backdated to the date that the warrant is issued, which poses other issues, which I understand we're not here to talk about. But I agree with Reed. Like, I think it is best practices to make sure that the judgment is correct and to, you know, advocate to any modifications that need to be made. I think that is in the best interest of our clients. But this is another situation where these practice standards are not in alignment with the proposed contracts. And that's something y'all are gonna have to reconcile.
Setting aside
Yes.
briefly the contract issue, and I have the benefit of not having looked at the drafts, and also I guess the benefit of having practiced under some pretty old contracts at this point. My practice has always been that I represent somebody until their case is done. That means that what I tell my clients is that I close their file about 60 days after the judgment's final. Because that's about how long it takes for everything to actually be over. Because that's what their case is actually over. And typically they are either off to prison or they are on probation, or I have given them the expungement paperwork and they have taken that to the courthouse. And those are like the three true outcomes, right? Either the case is done one of those three ways. There are some issues with the contract, I think, to the extent that it puts us in a position where it is asking us to cut off our representation before the case is actually over. I think that our standards need to tell us that we represent our clients until the case is actually over. And I think that this language puts us in a position where it's telling us to do that.
Right, but the contract also has a list of post-judgment obligations that is
Mhm.
more extensive than this thing. So it's like I guess the question is, is a contract internally consistent? Right.
It's
If
not.
it ends in judgment, but
It sounds like it's not.
It's not.
And that is not something that we're going to solve in the next 2-3 minutes. So the question still remains, what do we think is the best practice? Is it what we have here? Is it what's in the contract? Is it something else? Because if it's what we have here, we're good. If it's what's in the contract, let's just put what's in the contract in here. If it's something else, let's put something else in here. And if it's, if at the end of this we have what we think is the best practice in the best practice document, then you're not wrong that at some point the agency is going to have to square best practices and contracts. But we're not going to do that now.
Yeah, honestly, I think what's in the contract should be what's in here. Otherwise, we're just signing ourselves up for doing a bunch of free work. And I know I come back to the money again and again and again, but the reality is the biggest problem we have with retaining people is you can't make a living at this gig. So we have to take that seriously every step of the way.
And just so everyone's clear, what's in the contract is far more extensive than this.
yes.
And then
It
we can find
includes
about
seeking
everything.
modification of judgments, litigating issues of restitution, completing questionnaires, forms for appeal, seeking court orders, remedies on behalf of the client in terms of sentencing or disposition favorable to the client, filing a motion for new trial, filing motions for reduction of certain felonies to misdemeanors, consulting with the attorney representing the client on appeal or post-conviction relief, and upon request, providing copies of the entire file to appellate or PCR attorney is what's all
That's
in contract.
Okay.
I think the only thing I can think of that we should add there is, if it's not somewhere else, is that we should also make sure that we include an obligation to give our clients a copy of the file.
Well, that gets very expensive, especially with the digital redaction.
Yeah.
That
Yeah, that's
and the OPDC is not paying for that.
Yeah.
So,
Yeah.
and we
I
can't.
mean, we can charge our clients a reasonable rate for it, just like any other lawyer, but
I'm not sure we can.
I mean, I think for
I'm also
I
not
think for
sure that under your
redaction, we
contract you can do
could,
that.
but we also have to do the redaction anyway to give them the stuff that we have to give them, right? Like OPDC pays us for the redaction the first time we do it anyway.
All right.
Right? Like that happens.
So for the rest of this, Monday by like 4 o'clock, if you guys go through this, have any comments, if you can't sleep over the weekend, you really need something to help you count sheep. Email Colin, me, feel free to include the rest of the group, and we will work that in. From here, the standards go to the commission. We're hoping at their August meeting for their briefing meeting, and then at their September meeting for a vote, I think is our timeline for the criminal part of these, and the remaining practice areas to follow that. So that's kind of where we. Go
And
ahead,
then
Reed.
we're gonna stand up a training program for all of these ideas, right?
That's the plan. All right. Before we go, I do want to say thank you again to everybody for helping out with this. I know that let's put it this way. I know that things are kind of rocky with the contract terms proposed, and that there are a lot of feelings with that between the agency and all of the contractors. I'm sensitive to that, and I really do appreciate you all coming out to help with this while we're going through the other stuff. So thank you.